Good evening, everyone, and thank you for this opportunity to open our next series on legal English. I'm glad to have the opportunity to speak with you today and to open this series. My name is Jennifer Euler, and I'm from the Regional English Language Office that works together with the U.S. Embassy in Moscow. And I first of all want to thank everyone at the Legal English Center, particularly Sofia Barinova, for their support and initiative in making this project happen. It's our third learning opportunity on legal and financial topics, and I'm very excited to welcome all of our partners and participants. The interest in these topics has been outstanding, and it's something I'm very proud of the partnership, as well as all of the people that are able to join us from universities, associations of law, and the legal community in Russia. This webinar series, our third series, will provide a deeper look at the language of law. We're going to cover a lot of great topics: common law, tort law, civil law, property law, tax law, and additional topics that will come up together with a fantastic American English language specialist, Danielle Capretti. I know you'll take advantage of this time to focus, to perhaps deepen your understanding both of the content as well as the language. It's exciting to find a common language. It's not only exciting, but important to find a common language as a basis for international collaboration in law and in so many things beyond that. Part of the U.S. Embassy's mission in Russia includes providing opportunities for learning language and for teaching language, practicing English. Finding these kinds of common ties through common language creates discourse for relationships between the people of the United States and Russia. We're committed to providing free opportunities for learning English and teaching English. We have courses for all ages and different topics, legal English and beyond. I hope you'll investigate some of the resources from the Regional English Language Office, and we welcome your initiative as well as your interest. I'm sure this is not the beginning of many of your English language learning journeys, but I know the additional investment will continue your journey that will hopefully connect and deepen in these months beyond, but also much further than that. I encourage you to be in touch with the Regional English Language Office to find out about more opportunities. I want to introduce you today to our English language specialist working with this series. We're so lucky to have a well-known English language specialist and teacher with 20 years, more than 20 years of experience in many countries, including Germany, Great Britain, Finland, Estonia, Italy, Romania, Albania, Croatia, Peru, Pakistan, Canada, and more, now Russia as well. Danielle Capretti has this very unique qualification of both being a lawyer and an English language teacher. And she received her law degree and began her professional career as a lawyer in law firms in London, Syracuse, and Glasgow. So literally spanning a couple of continents. I know you'll enjoy working with her in this series that opens today on March 1st and will continue through the middle of May. If you miss the series or a webinar is so good that you want to go back and rewatch it, it will live on the YouTube channel for this series, so you can go back and repeat and learn more. With that, I just want to say welcome to all of you. Take advantage of this opportunity in the series of webinars. I know all of your efforts will be worthwhile in building bridges between our countries and learning to speak a common language. I wish you all the best in this evening of learning and understanding each other. And I feel like it's a very special moment. Today is March 1st. In the United States, we mark March as Women's History Month. And I know that one of the biggest holidays for women is coming up next week on International Women's Day. So I wish all the women lawyers out there a lot of congratulations, but I think it's a special opportunity to highlight strong female professionals in this series, both in our host from the Legal English Center, Sophia, as well as our specialist, Danielle. Have a great evening, fantastic learning. I'll give the floor now to Sophia and Danielle so you can start your evening. Thank you.
Thank you very much, Jennifer. And we are very glad to welcome you everyone tonight. I would like to speak about the logistics of our webinar. So right now, in several seconds, I will give the floor to Danielle, and she will be providing us with a presentation. I'll be speaking about the civil law versus common law key terminology. And on presentation, you will see in the top right corner the numbers and the address of a website which is called vvox.app. And over there, you are very welcome to insert the code that you will see on the top right corner, and you will be able to vote on the questions that Danielle asks. It's very good, it's very interactive, and we are excited that we have such an opportunity to have interactive webinar. Also, if you'd like to, you can write your answers to the questions in the comments to our YouTube channel. So, and Danielle, I'm so happy to introduce you to our audience, and we are so looking forward to this webinar. Thank you so much, and I give the floor to you.
Good evening, everyone. I am so delighted to be here with you to discuss the differences in civil and common law in terms of terminology. Now, as you can see, I have a JD after my name. And I would invite you in the chat box to perhaps think about what that JD could possibly mean while I discuss how I got this JD. To get a JD, it is an American law degree. And first, you have to do 4 years of law of any subject. So you have to do a first bachelor's degree it could be in French, it could be in literature, it does not matter. And then we spend 3 years of law school. And after you spend those 3 years, you graduate with a JD. And I don't know what your suggestions were in the chat box, but it does mean Juris Doctor. So how does this compare to how Russian lawyers study, Sophia?
Well, actually, it's very, very different, because we can go to our law school, we call it a law department or law faculty of any university right after high school. So it's already at the age of 18, you can already enter your studies to become a lawyer. And we have a bachelor degree, which is 4 years. And then if you'd like to, you can receive master's degree, which is 2 years. So basically already after 4 years, at the age of 22, you can qualify to be a lawyer. And we don't have any license. Actually, we don't need any license to practice law in Russia unless you have a status, if you want to receive a status of an advocate. For this, you need to study more and you need to take special exam. But actually, sometimes Russian lawyers are very young, so, and it's very different.
Yes, it is very similar in the States. We have to take a bar exam. I took the bar exam for New York, and happily I passed on the first try. Some people have to try several times, but I passed it on the first try, and I was very happy to.
Yeah, I know personally a guy who tried 4 times and still didn't do it, the bar exam in Florida.
Yes, Florida and California are the hardest. So, before we get into the meat of the presentation, I want to thank the fabulous female team who has put together what we're doing today. So thank you to you all. And as Sophia has discussed, this is how you join the VVox app. So you go to the app and you plug in the number 158-182-732 or scan the QR code because I have lots of questions for you. And I'm also here to learn from you. I'm very interested to see how Russian lawyers do things and what type of legal terminology that they're using. So on that note, I would like you to be thinking about what are the key features of Russian civil law, key words. Maybe there's a key statute or key code or the name of your constitution. Please type in some keywords for me.
Okay, and just a second. I'm also trying to get into Vivox.
I see some answers are coming.
Yes. And it's very interesting actually to what kind of answers we're going to get, because it is very specific. And actually we already have some also comments on YouTube, and we will compare also. I can already speak about it. So we have some people who say, should I say them now or should we wait until the end of voting? What do you think, Danielle?
Whatever you prefer, Sophia, you are the expert.
Well, I'm afraid that as a teacher, I'm afraid to give a hint to those, who are submitting their answers right now. So, and they will copy.
Okay. What I would expect, is for me, as a common law lawyer who knows very little about the Russian system, but has worked with lawyers from other civil systems, I would expect constitution, code, civil procedure. I would expect the name of your key. I would assume that you would have a criminal code and a civil code. These are all assumptions that I would be making as a common law lawyer. But you may have some, as we say in English, tricks up your sleeve, and you may teach me some things that I don't know.
Oh my goodness. So actually, for now, I am afraid I'm still so nervous because we start this series from the very beginning. I will just read out the answers from the participants who are commenting on YouTube. So it's codified, statutory law, it's part of continental family, statutory. So these are the words. So, and should we have a look at the poll?
Should we have a look at the poll?
Yeah,
okay.
I suggest we do.
Okay. Let me move on to, we missed the poll.
Okay.
Okay. I have, let's see, here we go.
Ooh.
Oh, wow. Okay. So I'm seeing codified, code. You have a bachelor's degree, Roman law, federal laws, a strict, tricky code. That's fascinating.
I like the word tough.
What do you think tough would mean in this context, Sophia?
Oh, this is such a tricky question. I think that it's very difficult to comply with this law. So, and I think compliance is hard, and that sometimes we would like to have maybe more flexibility on some of the issues. And maybe also for some of the laws to be amended and to be passed faster.
Okay, thank you. And thank you for this wonderful introduction. I think I didn't do too badly in terms of predicting.
Yes.
But I'm the tough one and strict and tricky, very, very interesting. Okay, so let's move on to what I think is the fundamental difference. Now, notice civil law, we were talking constitution and codes. With common law, notice I put constitution in parentheses, and I'll discuss that a bit later. And then I have this green word, cases. And that is a significant difference between the two systems. So I want you to that is the overarching principle that we will be working from today. Now, let's move on to the key features of common law. We're going to talk about 4 today that I think are important for any civil lawyer to know in terms of what vocabulary we are using. Now, another poll. Now, let's look at the world of common law. So, which of the countries here have adopted a common law system or a mixed system with some elements of common law? So, you can participate in the VBox poll. You can also put your answer in the chat box. Sophia and I had a very good discussion about this table here. And we had some surprises, didn't we, Sophia?
Yes. And I already forgot what I answered.
That's okay. It's there's one country here that you would not expect to be what it is. And I'll give it away soon. I'll give it away soon. So we have about, I see we have about 44 answers here. Do we have it? What's coming in on the YouTube?
Just a second. So are all of the above, all of the above, all of the countries listed? UK.
Okay, so now we have to go. I want to go for a bonus question. Let's have a look at the poll. A lot of people have answered here. Okay, it should be okay. Okay, interesting. Okay, so the correct answer, I see some people were doing multiple choice here, is all of the above. Now, the big surprise here should be which two countries have a mixed system. So there are two countries here that have a mixed system. The first one we really weren't surprised about, which was India, because as we know, India was part of the British colonial system, and they imposed their system of law and government on when India became a colony. There's another one that's a real surprise here. Do you remember us having a discussion about that?
Yes.
That country, Sophia?
Yes, I remember. So if I'm not mistaken, I don't remember much. I think Canada. I think
Yes,
it was Canada. Yes.
So I think next, let's go to the next slide. If we look at the world of common law, you can see that it's very much related to England and its former colonies. So you and English-speaking countries. So you have, the UK, you have Ireland, you have America, Canada, Australia. India has a mix now. And notice here in the eastern part of North America, the northeastern part, Quebec was influenced by the French civil law system. So that has a bit of a mix of a law. And that's actually should be a surprise for many people. But as you can see, Europe is it's a block. And I didn't know when I was preparing this how common civil law was in Europe. So that was a learning experience for me too. But you're a massive block in Europe and Russia. So let's move over to the common law system now. I want to know the key features that you know or have heard about from the common law system. And also, I'd appreciate your contributions from you two.
Yes, we do have actually a couple of questions. So
okay.
The question, while we're waiting for the voting, for answers from the poll, so we have a question about Louisiana. So as I understand, someone recognized the state which is in United States, which was the only state where you have a mixed system. And the question was, why is it like this?
Because there's a massive French influence in Louisiana. And you're absolutely right. That is a very fine point of knowledge. So whoever asked that question,
yes, it was Andrei Kashin. Actually, I can even say that he said that the question was about Louisiana. So because he noticed, and it was very interesting to see that in a huge country with common law system, one state can be so independent, and that is amazing.
And that's also an excellent point that within the United States, each state have a lot of power to make laws about certain areas. Like, for example, matters of crime are usually devolved to the states. So things like robbery, murder, and this type of criminal law is usually decided by the individual states, and they can decide as they like.
Okay, thank you very much. And actually we have some, I suggest we finish up the poll, and while we are getting the results, there are some comments from YouTube. It's stare decisis, the rule of law, the rule of precedent, judge-made, precedents, Anglo-Saxon. Common law is based on precedent court cases, and also habeas corpus. So we have a lot of interesting vocabulary.
We do. I'm very, very impressed by the knowledge of stare decisis. I thought that was going to be a magnificent new term that I introduced you all to today, but I see it's right here, and it's also right here from our surveys. Let's see, we have precedent, which is very important. Interestingly, there is a bit of a disagreement here. We have someone saying codified laws, and then someone saying no codified laws. So that's something that we will discuss when we talk about the hierarchy of laws. Binding, hierarchy of courts. Okay, I'm very impressed by your level of knowledge of the common law system. So bravo to everybody in this webinar. Flexibility is also a very, very appropriate word for the common law system. So this is impressive. So 5 stars to everyone who participated. Okay, so let's move on to the features of common law. The most important overriding feature is that the Constitution is optional. And I know this is quite strange for a civil law lawyer, because from the Constitution flows everything. Now, what I will say is it is also strange for an American lawyer who is living in the UK, so I live in the UK, to live in a country where there is no constitution. So let's discuss that divide. As many of you will know, the American Constitution ratified in 1789, and we have been following that document for all our legal processes for quite a long time. Within this document, we have articles, but we have also recognized that that document wasn't perfect, so we can amend it. The first 10 amendments discussing things like freedom of speech, freedom of religion was the Bill of Rights. And again, early on in the history of our country, we enacted these Bill of Rights into law. But over time, we have made new amendments, and these amendments have to be ratified by 75% of states. So it does take a long time to get things done, but we do have that Constitution. The UK, as another common law country, is a bit different. Now, they have what is called a living constitution. So there is no overriding document. And what they say is every law ever passed, even if there's a law from the 1300s, that is part of their constitution. This is very strange even for American lawyers, but it works here in the UK, and it's very much, the British approach is very pragmatic, so I can understand why they had this living constitution. However, just be aware that during the EU membership, the treaties, Treaty of Rome, Treaty of Maastricht, they became the British Constitution. But as we know, the UK is no longer a member of the EU.
And also, sorry,
yes.
Danielle, just wanted to say that please, everyone, if you have got any questions, please write them in the comments on YouTube, and I will be more than happy to deliver them to Danielle, and we will discuss them. So, because we teachers love the questions. So
yes, I would be very happy. And the questions so far have been very, I would say, erudite, very displaying a high level of knowledge. So I'm really delighted how engaged this audience is. Okay, feature 2, the importance of case law. Obviously, that is a major feature of the common law system. And in all the common law countries, case law has a significance. So I want to find out, though, about what your system is like. So how important are court decisions in the Russian civil law system? I'm very intrigued about this because I have no idea what the answer will be. But while we are taking this poll, and please write in the YouTube, Sophia, we had a discussion about this term, court decisions versus court practice.
Yes, actually, so because in Russia very often we will, and we changed it a little bit, so when we discussed this question, so in Russia, when I ask my students, so do we have any features of precedent law or case law? So everyone starts speaking about court practice, and by this term, usually Russian-speaking lawyers mean the decisions of some very high court, usually the Supreme Court of Russia, so, and some very important courts, the courts of appeal. So, and this is what is meant in Russia under this term. So, and as I understand, the expression court practice, in your understanding of this term, is different.
Yes. So, as a common law lawyer, if you say to me court practice, my head immediately goes to court procedure. So, if you use this term to describe what happens in the Russian system, that is fine, but be aware that a common law lawyer is going to need you to explain it. Mm-hmm. And this is why we put these wonderful quotations here. Yeah. So now I know the word and it's explained to me. So if I'm speaking with a Russian lawyer and they say court practice, okay, I understand what that means. But the first time you use it, make sure that you explain it, that these are court decisions rather than the procedure of the court.
Yes, because in English, everyone translates it as exactly Russian expression, судебная практика. So it's just literally different understanding. Mm-hmm.
Yes. Yeah. I mean, and this is why we have, discussions and seminars like this. We bridge the understanding with just a little bit of explanation. Okay, is it time, Sophia? So, yeah. Mm-hmm. So what's coming from the YouTube in terms of this survey?
So only, there are a lot. So of course the favorite answer of all the lawyers, it depends. So
yes.
So not so important, but it depends. Only decisions of Supreme Court. So the court decisions of the high courts are very important and are binding. And it's not collected in one single document. Only Supreme Court's decisions important. Constitutional decisions of Constitutional Court are not less important. Moreover, they are the most powerful source of law among case law. So
okay. So a massive, it depends. I see different, and you told me that there are differences amongst Russian lawyers as to what the real and the correct answer to this question would be. Okay, interesting. I would say that common law lawyers are pretty much settled on the importance of precedent, as we will see. Okay, so let's unpick some of these terms of case law. Where did this concept of case law come from? Well, it came actually from the 13th century when in England, if someone had a dispute, they went to what is called a court of equity. And this court decided what is fair. And then they made a judgment. And there became common law. They weren't going to go to the legislators and ask them to make a statute about the matter. It was party A has stolen party A accuses party B of stealing the cattle, and then they both present their arguments, and then the judge decides what is fair. And so that is the principle upon which the English courts decided cases. And again, it fits into this British pragmatism, not having an overarching constitution, but looking at things on an individual level. And stare decisis, that's the principle that this is related to. We stand by things decided. So if a judge decides a case and there's a new case with similar facts, we refer to the older case. Now, there are a few things that you need to know about precedent. And this would be, if you have questions, put them in the YouTube, because this is the meat of the presentation. I'll be happy to answer questions on these.
And actually, we do already have one question.
Okay. Yes.
Actually, it's very straightforward. Is case the same as precedent? The words, are they the synonym?
No, they are not.
Oh my goodness, no, Lord. Because we say precedent law, case law, judge-made law, and we use them as synonyms. That's why that's why there is the question.
And that's why I'm here to help you. Okay, you would never say precedent law. You say precedent, and then you say case law. And that's a first use a difference. Precedent is a case decided by a judge, which is used to decide a case afterwards. A case can be a case in the past, a case in the present, a case in the future. That is just talking generally about a legal case.
I understand, like dела in Russian.
Okay. You know the magic terms in Russian, yes.
Just a little bit help. I know we're supposed to have totally English class, but just a little bit of tricky.
Yes,
tricky
and you are dealing in a language that doesn't even have the same alphabet as yours. So, feel free to ask questions and seek clarification. And I'm glad that I can give this clarification while we're here tonight talking about these matters. Now, a few little points on precedent. When you are offering the precedent to the judge, it is very important that you use precedent that is similar to your case. So, for example, if your case is about the sale of a house, the precedent that you offer to the judge should also be about the sale of a house, not the sale of a car or a farm. If the case is very much like your case, we call this on point. If you are talking about the sale of a house and you bring in precedent about the sale of a car, the other side will say, I want that. We're going to distinguish that precedent because that case is about a different matter. Another important pair of terms is mandatory versus persuasive. Now, precedent is not mandatory all the time. It depends on the court. Obviously, something from the Supreme Court of the United States would be mandatory in all of the states and all of the courts. But something from the Supreme Court of Pennsylvania, my home state, may be persuasive in New York, but not mandatory. So the power of the precedent depends on the jurisdiction and also the court. If you have something from the very low court, from a low state court, it's very doubtful that that's going to be mandatory. It may be persuasive, but most likely when you think of mandatory, it's a big, important court that is up on the top of the court hierarchy.
So can we say
yes.
like persuasive, like support, like it's kind of supporting the case, but not like I'm trying to find the synonym to the word persuasive for our participants to understand. So it's kind of, so will it be used in the, I don't know, list or like of supportive precedents, or when you offer a precedent to the court, you just offer only one? Or
okay,
like...
Excellent question, Sophia. So as a lawyer, when I'm researching a case, the first thing I want to find is mandatory precedent. I want to find something from the Supreme Court or from the highest court in the state that supports my case. Often I cannot find that. So I have to search. And maybe I find a similar case in another state to mine, or I find a case from a federal court in another circuit than mine. That would be persuasive. So the judge does not have to follow that, but you will say, look, this federal court in another circuit decided something very similar. And I'm saying to you, judge, it would be a good idea that you follow this precedent, but the judge does not have to.
Mm-hmm. And one more question we received from the audience, actually. And when you offer your brief, if I may say so, to the judge, will it be like really like the headings, mandatory precedents, or persuasive, or not? It wouldn't sound like this, yes?
No, you would just
write it, yeah.
Quote these cases in the brief. And obviously, when you have a case in any common law country, there is a citation, and this citation will tell you, for example, if it's from the American Supreme Court. So if I'm reading a brief as a judge and I see this citation, oh, okay, that's a Supreme Court case. So that's pretty much mandatory, and I need to follow that.
Mm-hmm. And our two more. We really have a lot. So first question from английский с Маруся. What if you find a precedent that doesn't work in your favor?
Okay. So what you have to do, because the other side is going to use that precedent, so you have to distinguish, there's that magic word, distinguish that precedent and say, no, it's different. Mm-hmm. So what's going to happen really in the court, and we're going to look at the court a little bit later in this presentation today, is that you're going to get all of the precedents that support your case and argue them, and then you are going to distinguish all of the precedents that the other side is going to offer to support their case. Mm-hmm. And then the other side will have their precedents to support their case, and they're going to try to distinguish your case. Oh, no, that's different than our case. Mm-hmm. So yes, you have to look at you have to do a lot of research, in other words, to write a legal brief. It involves a very detailed research. And
one more question. So from Sophie, so does the judge absolutely have to agree with mandatory cases or not?
If the judge could distinguish the precedent, so the judge could say, this is a case of first impression, or the judge could, but most likely if the case is appealed, the case will be overturned.
Mm-hmm. Okay, thank you. That's very interesting. Thank you very much.
Thank you. Fantastic questions. Very engaged audience. That's what I love to see. And this actually leads us very nicely to another three concepts I want you to think about in terms of precedent. Precedent can be binding. Okay, it's good law. It can be overturned, which means maybe there's a case 100 years ago that was decided at the time, and now things have changed, and we'll be looking at such a case. And now that case is no longer good law, or parts of the case can be overturned. So parts of the case by judges can be declared invalid. And this has happened in the American Supreme Court a number of times. There are decisions that are maybe from the 1800s, and judges in the 1900s said, no, that was bad law. We are going to overturn the precedent and say it is no longer valid.
And there is also one more question
Yes.
from NT. Can you please say where are the court acts kept? Is there any electronic website for, like in Russia, we have all judicial acts are available, and they're like combined and are available to watch in one site?
Okay, yes, that's a really good question, and I wish we had more time for this. There are two important research sites for American and British law, and they're called Lexis and Nexis, and they are electronic databases. And you can go on these databases and you find the statutes, constitutions, cases, articles, treatises, law reviews. And what is really helpful with Lexis and Nexis is they have a system. So you'll see a case and there'll be a little light. So if, for example, it's a green light, that means the case is still good law. If it's a red light, the case has been overturned. If it's a yellow light, then some of it's partially overturned. So they LexisNexis definitely helps you because it's very hard to do this research. That all said, when I was in law school, we were still using books. So we didn't have all these wonderful electronic sources. So there were when you had a case, you had to look in different books and make sure that the case was still good law. And we had to learn all of this at law school.
Excellent. Thank you very much. And do you have to pay for this or not? For the access
Yes,
to this website?
Obviously, law schools will have it, and every law firm has LexisNexis. So it's something that lawyers will buy, because you can't really do proper legal research without one of these, or Westlaw. There are two. There's LexisNexis, and there's Westlaw, and you have to have one of them to do proper legal research in the UK or in the US.
Thank you. Thank you very much.
Okay, so talking about an overturned case, let's weave this in and also discuss ruling versus dicta. And I know, Sophia, you are very interested in this concept of ruling versus dicta. Why so interested?
Because I remember somewhere, and it was really unusual for me that the judge doesn't actually say that this is ruling, and then, like, I don't know, space, and now this is dicta. And I was always amazed how lawyers can actually understand what is what when they read the precedent. Is it like highlighted or something like this? No.
And interestingly, lawyers will argue about this too. So that is also an element of training in law school. Again, in Britain or in the US, Canada, we are trained to analyze, to find the holding or the ruling of the case. There could be a disagreement. So one lawyer can say, this is the holding of the case and this supports our case. And then the other side can say, no, that's dicta. So there are disagreements about that.
And can you please clarify what is dicta?
Yes.
Because not everyone knows.
Yes. So what is important is that a ruling is a sentence or two sentences about every issue of law. So if there's one question of law, there'll be one ruling. If there are 7 questions of law, there will be several. There will be 1 or 2 sentences of ruling. Okay, that is a very small part of the case, and the rest is dicta. Let me show you an example. This is a very famous case from the US, Brown versus Board of Education. And this case overturned the policy of segregation between white Americans and African Americans in school. Great, fantastic. And it overturned the Plessy versus Ferguson case, which said that facilities should be separate and equal. And this case said that all children, American children, should go to school together. Okay, so it's a great, important case from the American Supreme Court. The holding or the ruling, those are similar terms, or the verdict, is this one sentence, okay? And the judges have given you a clue there because they've used the word hold, but usually you don't get that clue. We hold, okay, are people who are, by reason of segregation, deprived of equal protection. This is unfair. So the rest of the case, all of the arguments of the judges and all of the legal reasoning is dicta. Now, dicta can be persuasive, but dicta is not the holding of the case.
It's just kind of opinion of the judge or explanation or supportive arguments.
Exactly. And it can be persuasive. There are often, I mean, it's a Supreme Court case. So, if a judge is writing, they're a very learned legal scholar and, what they say, but that was not the ruling. So again, if I go and quote the legal reasoning of the judge for one of the arguments, that's great, but it is dicta and it is only persuasive.
So inside a mandatory precedent, we have a dicta which is persuasive.
Exactly.
Okay, and actually we have a question.
Yes.
Getting back to the databases. So a question from Sophie, does that mean that full laws, we still use the word laws because we're civil law lawyers, are not available to lay persons, to regular people? So I mean available for reading and getting to know them.
Okay, an excellent question. Yes, they are available. They are available, for example, the state of Pennsylvania will have a site and you can search the laws. So people can read laws. But in terms of searching for cases on a particular subject, for example, it is almost impossible these days to do it without a legal database. You, as a lawyer, I mean, you could do like a Google search, but that is not going to give you what you
picture.
as a legal professional would need to argue the case.
But
yes, there's freedom of information in terms of laws and regulations. So if I go to the website of the Pennsylvania government and I want to look at a particular law, they will have that law they will have that law there. It helps though, LexisNexis, they'll have the law and they'll have all of the regulations, they'll have all the changes of the law. So there's a lot more detailed information that lawyers, as opposed to laymen, would want to know when they are dealing with a case.
Okay, thank you very much.
Okay. So let's move on to the hierarchy of authority. So, given from what I've said and what you know, is case law more important than statutory law in the common law system? I'll be very interested to hear what you.
These are such tricky questions, you know.
Yeah, these are lawyerly questions.
Yes.
These are lawyerly questions for lawyers.
Okay, so. And actually, while we have our participants of the webinar who are voting, there is one more question. So, and it's very interesting. It is a question on ratio or ratio decidendi. I'm sorry, I'm pronouncing some of the terms incorrectly because I'm pronouncing it more in Russian way. Then the question from Andrei, then, can you please explain what is ratio or ratio decidendi? From the president, as I understand, he meant a ruling. So ruling is ratio decidendi, and obiter dicta or dicta is the explanation or persuasive opinion of the judge, if I may say so. And and we have got several more questions. So related to the precedent that we had, guaranteed by the Fourth Amendment, it doesn't mean Constitution of UK or USA. So it was the case from our US.
Okay. So if we go back, let me, I can't, I don't want to interrupt the poll. Let's talk about ratio descendant. Okay, so what is important to know here is that there are a number of synonyms that are used very interchangeably. Ruling, verdict, decision, holding.
Judgment? No.
Judgment.
No.
Judgment is a little bit of a broader term. Most of these terms are synonyms. The thing is that a holding would be a lawyer-to-lawyer term. So you would never say to a client, the holding in this case is. Okay, a client would know words like verdict, decision, ruling, but they're all dealing with that one sentence per issue of the case, not the dicta. When we talk about the judgment is a little bit more expansive, the court's judgment. So that one is dealing more with the text and the reasoning.
Okay, understandable. Thank you very much.
And the one dealing with the 14th Amendment, if you see the word Constitution or amendment, it will always be American law.
Yeah.
And so that's, if you see 14th of any of this Bill of Rights, these are all American law principles. So that's an easy way to, oh yes, this is an American case. And again, if you go into citation, there are different ways of citing American and British cases and Canadian cases. And once you learn the conventions of citation, you can look at a case and say, oh yes, this is from this country and this court. And this is what we're trained in when we go to law school. That's a citation is an important part of our training.
Okay, excellent. Thank you very much. Super.
Okay, so let's have a look. Okay, so the majority agrees with me. Yes, I gave you a very lawyerly question, and the majority has been very lawyerly. But I really want to go into a bit more detail here, because when we talk about case law, there are civil law lawyers that I've worked with who are like, I don't understand this, or you don't have any statutes, or how can you have just cases, and isn't it confusing? So let's talk about where cases fit in the hierarchy of authority. Okay, so this is my magical wheel and my magical triangle, which are very striking. They're from Harvard Law School, and I hope this is an easy way to explain the hierarchy of authority. Now, the most important thing is this triangle here. You notice here, what's at the top? Constitution, statutes, treaties, regulations. And case law sits at the very bottom. The most important point here is, if there is a statute on your case or your problem, a statute governs that area, that is what you go to first. You look for a statute, you look for the Constitution. If there is nothing in the Constitution or the statutes or treaties or the regulations that deal with your specific legal issue, then you go to case law.
Yeah.
Case law will never be more important. For example, again, let's look at Pennsylvania.
Yeah.
The case law of Pennsylvania will never be more important than a statute from the legislature of Pennsylvania on that same topic. So case law is what we go to if there is nothing written by the legislator. And that's probably, for me, that's for you, that is the most important takeaway that you should think about today.
Yes, because a lot of people have a misconception that so they're like are equal, and you can pick whatever you like, either a statute or a case, which is, and for example, if something, well, a question is, can they contradict? Can a precedent contradict the statute? So, for example, can you encounter a situation that you see a statute and I think, no, it's not possible? So,
if it's a bad judge, but in theory, the judge should follow what the statute says. Any decent judge should follow what the statute says.
Yeah, silly question. So of course they would follow. And can I ask a question, please? And I'm supported by one of our participants. There are two questions actually. What is regulation? And secondly, is statute and law, are statutes and law synonyms?
Okay. Again, very erudite and highly intelligent and highly informed questions. Okay, so a regulation is made by an administrative department to explain the statute. I'm wondering if you would have such a thing in Russia. So if we would make a statute, for example, on employment law, the statute made by Parliament or made by one of the legislatures in the US would be quite general. And sometimes this statute would need to have the details explained further. So the legislation would be passed to a government department, which would deal with the finer points and add more specificity or details. As you can see, regulations are not more important than statutes. They explain statutes and they are written by the executive department of the government. But they are also more important than case law. So again, look at the statute, see if there are any regulations explaining that statute, and then look, if there's nothing there, then you go to case law.
Excellent, thank you very much. And the second question, does statute mean law? So are they synonyms?
I would say if we had a big circle and that is the law circle, statute is a type of law, but they would not be synonyms.
So it would be synonym of act, maybe statute like act. No?
Yes. Yes.
Okay, very interesting.
Really impressive questions. I'm highly impressed by the intelligence and the education level of our audience. So bravo.
Yeah, really the source of finding out the information and clarifying. And I'm so happy that actually we have this topic tonight. So Daniel, you were right. You were so right from the very beginning.
I'm so glad. Thank you. Okay, so that is that triangle. Now let's look at this circle. Well, let's look at this circle here, which gives you a nice summary of all of the sources of legal research. I'm curious, Sophia, in Russia, when you present a case, do lawyers spend, like in our system, lawyers spend hours and hours writing a brief, preparing a, is it a different thing in Russia? Do they spend hours looking at different documents, or is it completely different?
I suggest that we ask this question to our audience, and after a while we'll try to receive the answers. So everyone, I would be, those of you who are watching us right now, so can you please try to write what do you do? Do you really spend hours so researching, writing? Because, and then I will read out the answers. Okay, let's give some time.
Excellent. That's wonderful. And I'll emphasize a lot of time in law firms is spent researching all of the different elements that could input to support the case of our client. So if we look at the primary resources, Sophia, can you tell me which of these words would you like me to explain a bit further for our audience?
I would say ordinances.
Okay, ordinances are made by the city. Okay, they are city law made from the city. For example, like picking up of rubbish or garbage, that would be an ordinance. Also, you know, how a park operates. So any law that is made by a city.
And one more, jury instructions. Are these instructions given to the jury, or these are explanations given by the jury?
These are instructions given by a judge to a jury.
That's very interesting.
Yeah,
and very unusual, actually.
Yes, the judge will formulate the legal questions into something where a jury is saying like guilty or not guilty, and that those which are those questions which are formulated by the judge, and the content of them, how they're supposed to reach their decision, these are considered primary sources of law.
Very interesting. And we actually have got some answers to the questions that you asked. So how much time do the lawyers spend in Russia researching actually the law and regulations? And the answers are very, very different as usual when you speak about lawyers. So someone says it depends, as usual. Someone says not. Someone says yes, I spend as much time as necessary to support the case, to be persuasive. So then it depends on the difficulty of the case, but mostly it takes not so much time to prepare. So some people say a lot of time. So the answers are very, very different.
Okay, and I will, when we go to the point 4 and we talk about the system, I'm going to talk a little bit more about that division of labor. So that will lead us nicely to that. So let's move on to the secondary sources. Now, in terms of our triangle, secondary sources are even under case law. Okay, so all of these resources in sort of the red, you would deal, again, Constitution, statute, treaty, regulations, case law, and then if you find nothing to support that, then you're going to the secondary sources. And again, Sophia, which terms would you like me to discuss further?
I would say several head notes and annotations of whom.
Okay. When we put the case in the case book, like for example, Westlaw puts a case, and in each paragraph, it will, in each part of the case, it will write headings. Okay, and to sort of give you like the subject matter of the case. That's called a head note. Annotations are extra notes.
Like comments. We will call it comments, yes, on something.
Yes, extra comments within the
and
case.
Then what is the difference between American law reports and law reviews? So who gives them? So what's the difference in them? So I may be asking very simple questions, but I understand that some people would not know them.
That's absolutely fine. And maybe sometimes also we think we know, but we don't actually, we've been misinformed on some way. So it's always good to look at these terms because they're all key terminology for common law lawyers. Okay, a law review is written by, for example, I was on the Syracuse University Law Review. Okay, these are legal articles which are written about certain topics. You know, the law of contract. So somebody would write the law of contract for football players, something like that. And journals would be academic journals, so professors writing their opinions about the law. American law reports are a little bit different. They are actually a company which summarizes points of law. So, for example, you have a case and you have no idea where to begin. You have no clue. So you can go to the American law reports and look up a topic and see what the general law is. For example, the law of contracts in a certain state.
Mm-hmm.
What are the general principles? And that will give you a starting point for further research.
Okay, excellent. And then, thank you so much. And then treatises, I'm sorry, treatises and restatements as well, because I think out of all of this, I know only dictionaries and encyclopedias.
That's okay. Treatises are very interesting. So they are books written by the best legal scholars. And believe it or not, I still remember in law school, there was this big book about this big, and the man's name was Chitty, probably an old
yes,
English
even we know Chitty, yes.
Chitty is, on contracts.
Yeah. Yes, Chitty on contracts, yes.
Exactly. These are, again, summaries of laws written by legal scholars for beginning lawyers, or for if you do not know anything about the field. These are, again, secondary sources. The restatement is not a scholar, but again, these are summaries of law. You have the restatement of torts. So again, you would go, oh, I know nothing about torts. Okay, let's look at the restatement. The restatement again is it's almost like a business.
It's like for dummies. Can I say so? It's like can I say that it's like a summary for dummies, or like in very plain English, sort of?
It's not okay, I know what you mean for dummies. No, it is for lawyers. All of these documents would be by lawyers for lawyers.
For lawyers, okay.
Yes.
Mm-hmm.
Yes.
And actually, we have a question, a very interesting question from Magomed. Can we summarize and call secondary sources as a doctrine? That's a very specific question. So,
I would say not. In some cases, yes, but in some cases, no. Because things like dictionaries and encyclopedias, they're not really doctrine.
Mm-hmm.
But
okay.
I'm glad to hear you thinking creatively, because I think what the idea behind it is a very good one, because we're getting away from anything that is made by a judge or a legislator or the executive branch. We're getting now to sort of legal experts, whether they be law professors or people writing in law reviews, and this is less authoritative.
Mm-hmm. Okay, thank you very much.
So let's move on to tertiary sources, but let's move on briefly, because I want to get through the adversarial system, which is a lot of fun. I think the one word there that Sophia, you had a question about was Hollis.
Yeah. This
is simply for Harvard, and I've taken this from Harvard Law School. This is the library catalog. And you can quote a library catalog if you need to, or a law library website that you're researching on. But again, this is when you have no other resources, and you're thinking, okay, I have to go, and sometimes you have to reach, perhaps it's a new area of law that we haven't dealt with before. The law of bots is a new area of law. So that's where you go. Let's move on. We have about 20 minutes left. So let's move on to the adversarial system, which is the fourth and the final feature that I want everyone to think about as, yes, this is common law. Now, I've said adversarial and not inquisitorial. And I know when I put inquisitorial, Sophia, you said, oh, Russians will say, oh, that's That's a...
Well, a little bit, because in Russia we immediately associate the word inquisitorial with inquisition, which dates back to medieval times, to a church term when the representatives of the church were trying to follow the people who were against the church, and they were burning them. So this is the only word, this is the only association most people have with such words. That's why it sounds a little bit like, not a bad word, but not very, a little bit negative connotation and association.
Okay, and I now completely understand that, because we actually, that's also the word that we use. We talk about, for example, the Spanish Inquisition in English.
Mm-hmm.
Inquisitorial as an adjective is a little bit more neutral and even positive. And as common law lawyers, when I was first speaking with civil law lawyers, they talked about this being an inquisitorial system. And it really makes sense, because from my understanding, in civil law, you want to find the truth. That is the objective of the court case. In common law, it is adversarial. So we are fighting. And I think that this principle of being adversarial is really reflected in how we organize our courts. So this is a court. It would be a civil court because we have plaintiff and defendant, and it is a jury case. We have our jury box. Sophia, how does this lay out different from what you would see in Russia?
Well, in Russia, if we do not have a jury box, so very often we have the judge in front of the judge, from what I have seen, but of course our participants may contradict me and write their comments on YouTube. So usually in front of the judge we have like a long table, and the parties are sitting in front or at this table, so it's like letter T sort of, and the judge is sitting or presiding over the case at the head of the table, and the parties are facing each other. So they're sitting very often literally in front of each other. But of course, if we have a jury box and a big trial, then the layout will be very similar to what we see in the picture. So it depends upon the case, and so.
Okay. In the common law system, the plaintiff and the defendant would never face each other. I was quite shocked when you said that. They would never face each other. And
in civil cases, in criminal cases, it's the same like this, but in civil cases,
okay.
Yeah. Mm-hmm.
Okay, interesting.
Mm-hmm.
What's important about this picture is how the plaintiff and defendant, who will be sitting beside their lawyers, are in the center. They are the stars. And that is very important in the adversarial system. The lawyers are really the people that do all of the work. They are the ones working much harder. From my understanding, in the inquisitorial system, the judge is a lot more active, whereas in the adversarial system, and I'll show you the jobs that people normally do in a court in a moment. In the adversarial system, the judge stands back a bit more, because in the adversarial system, we are arguing, and whoever has the best argument wins. Now, a bad result is that you could have a wonderful case, but if your lawyer is terrible, you could lose. But hopefully, if you have a decent lawyer and they are looking at all the right precedents, everybody is putting the best case they can to the judge for their client.
Mm-hmm. Thank you very much. So, and we have got several questions actually. So, if there is any jury in civil cases, can there be any jury in civil cases or not?
Okay, very good question. I think a lot of the civil law lawyers I have worked with have an idea that there are many, many juries. There can be a jury in a civil case, But most often this right is waived. This right is waived just because the amount of time that it takes to get the jury together, to get the right jury for your client. So if the lawyers think that there is an advantage of having a jury, the plaintiff will exercise the defendant will exercise their right to have one. Mm-hmm. But a lot of the times they're waived just because the time and expense and the difficulty of having a jury. But yes, defendants do have a right in many cases to have a jury trial, generally in the common law system.
Mm-hmm. We have got several questions, but I think I will ask them at the end if we have time, so we can move on.
Yes, that's a good idea, yes, because I'd like to look at, so the jobs. So, as I said, it's the lawyer that is doing the work in the adversarial system. They are writing the briefs, they're making opening and closing statements to the judge and the jury, they're calling the witnesses, they're examining the witnesses, and they're cross-examining the witnesses of the other party. So the lawyers are extremely active here. I'll get to the solicitor-barrister difference in a moment. The judge is just like a referee. The judge keeps order. They sustain objections. And you see this, many films about law are silly, but the thing of the judge that I have, objection overruled, objection sustained, that is one of the few realistic things that you see in
and they're hitting this hammer or whatever.
The gavel. They're hitting the gavel, yes. And that all happens. That all can happen. The judge also reaches the verdict and may write an opinion. Obviously, like in the Supreme Court, they choose one judge to write an opinion for important cases, but not for minor cases. The jury, again, decides guilt or innocence on the basis of jury instructions. So the judge will give the jury very specific instructions and very specific questions to answer. And these questions are plain English. The judge's job is to make these questions so that any juror can understand them easily. In a civil case, they will decide if a claim is true or not true. And one of the things to remember about the jury, it must be unanimous. So they must all agree. If they do not agree, there has to be a retrial. Mm-hmm. And that is also a reason why juries are only used mostly in criminal cases, serious criminal cases, that juries are really restricted to those types of cases.
Thank you. Excellent.
Okay, so let's go for some questions now, Sophia.
So several, yes.
Excuse me. Before we do that, let's talk about solicitors and barristers. Yeah. Mm-hmm. So just be aware, in the UK, and I worked in this system, there's a division between a solicitor and a barrister. Now, Sophia, would Russians be aware of this difference, or would this be something that would be new for them?
To many people, absolutely new. If you do not research the English law and you're not trying to find it out, yes, very often it might be a problem.
Great. So the solicitor prepares the case, the barrister argues the case. This is very strange for an American lawyer. So I've worked here in the UK, in Glasgow and in London. And we would prepare and prepare and prepare. Then we would go to the court and give this big file to the barrister. The barristers are so well trained here, they can take a very complex file of cases, look through it very quickly, and then go and argue it in court. If it is a very complex case, they will have the solicitor sitting in the court. But you decide when you decide to become, after you finish law school, there's a different route to becoming a solicitor or a barrister. So those are the people that like to argue in court, they are given a certain type of training, and then the people who do office work, they're given a separate type of training.
Yeah. So
again,
it's kind of
Americans, that's strange.
And actually it's also quite strange for Russians. So especially if you give the job that you have made, you researched, and you give it to someone who kind of gets all the success, if we may say so. So it's kind of a little bit jealousy involved, if I may say so, be so direct. So, or maybe it's just silly to say so. And I would say that we explained to Russian audience that barristers are like litigators. So they're the ones who go to the court.
Yes,
so
exactly.
And
yes.
if I'm not mistaken, a question we usually get from the audience, and I would like to ask it also right now. If I were a client, can I go directly to the barrister or not?
No, not really, no. Obviously,
do I get to choose a barrister,
yeah,
or it's the solicitor who decides?
It's usually the solicitor, unless there's some backroom deal and somebody who's a great, but usually the solicitors built up relationships with barristers, and barristers usually specialize in a certain area of law, tort law, contract law. So they are an expert at arguing a certain branch of law. When I worked here, there was one barrister I worked in property law and torts law here, and there was one barrister that we went to for our property cases, and then there was another that we went to when we had a tort case. And it makes sense because they have this long-standing relationship, and so the client is ultimately paying, and there could be, but we never dealt with a client who objected,
who brought his or her own barrister into the case. Okay, so thank you so much. And now we have got many questions. So just a moment.
I think we have time for about 3 questions.
Oh, okay. So I'm sorry, everyone. I need to pick. So we have got like 20. So is it?
We don't have time for 20.
Yes. So I will be just picking the ones which are like standing out. So the question from Denise: is it true that in the USA the parties more often turn to arbitration tribunals than to the state courts if they want to resolve a dispute?
Arbitration is an option. And settlement is also an option. It will depend on a lot of factors. How quickly they want to resolve, because sometimes, I don't know how it is in Russia, but to get a court date in the US or the UK, sometimes it takes a long time, and arbitration is an easier route. I would say that was not used in the past, but it is becoming more common just because people want to settle their business and move on.
Okay, thank you very much. Then another question. So do UK, US lawyers really become emotional and give and present very active speech and trials like it is shown in the movies, or it's exaggeration?
Well,
that's a very good question.
Yeah, it is a very good question. I think what I get when I watch legal films, and sometimes I don't watch them very often because they just make me angry. I get angry when lawyers are doing things that they're not legally allowed to do. Like there's certain questions that no lawyer would ask the witness. And so that is problematic. I think barristers really enjoy their work. And, if you are arguing in front of a jury, it's important to almost, have to affect them emotionally. But I would say as a whole, it's a lot drier. It's a lot more drier and serious. I think with a lot of these legal films, no good lawyers would be embarrassed to do some of the things that you see in these films because their colleagues would just laugh at them. So I would say it's a bit toned down. But I mean, the cases, if you are involved in certain types of law, like a family law. Some of those cases can get very emotional. And I've seen, I remember going to the family law court and seeing quite emotion. Everyone was emotional, the families, the lawyers. And so, but it's a step back because there are certain procedures. And, when screenwriters write, they just get carried away with the drama.
Okay. And the last question, actually, from Victoria. So, getting back to the sources of American law, are law reviews part of law or legal discourse in terms of linguistics? Very specific question.
Okay, I need some more information from that.
Yeah, actually, also, Victoria, can you please maybe clarify? So, I mean, maybe, I think Victoria is a teacher or an interpreter, because the question is very linguist-like, if I may say so. So, what I mean is law reviews may be using the same terms or they simplify them. If I may freely rephrase this question as I understand it, maybe I'm wrong, Victoria, I'm sorry, but that's the idea. So,
okay. Okay, let me answer this on several levels, and I'm hoping I can satisfy Victoria's curiosity. So, law reviews are written for lawyers by lawyers. That's the first thing. So they will be written in legalese, technical language. That said, law review articles often deal with points of law that have not been decided yet. So they may speculate on a new area of law. Or we were encouraged when we wrote our law review articles, when I was on law review, to look at a new or developing area of law. So that could be the source of perhaps new terminology, especially if you're dealing with something in the environment or the or computers. But the most important thing to remember is they're written for lawyers by lawyers. So they're not in what we would call plain English. Most laymen do not read a law review. That we in the legal community will read law reviews to see the insights or to see articles that maybe summarize a new point of law or amalgamate several sources of law.
Okay, excellent. Thank you so much. Thank you.
Okay, so what is your most memorable word from today's session?
Oh, so very good, actually, question. So, because I think I will write the one that I mispronounced. So, because the stare decisis, because I was trying to pronounce it the more Russian way.
Yeah, stare decisis.
Stare decisis. Oh my goodness, Lord.
And that's not really, I believe that's the Latin pronunciation. It's not, I think in English, if we pronounce that in a proper English way, it would be stare decisis. So we are taking this from the Latin.
And I think, Daniel, you press the button to show the results, because we cannot access the...
I'm so sorry.
No, it's okay, absolutely, maybe...
okay, can you write, sorry about this. Oh no, okay, now
that's okay. That's okay, it happens. So it's called technology. So it's okay, absolutely. Yeah, so everyone, can you please write your answers in the chat box? So as usual, that's very often happens. We deal with technology. So and
we were doing so well.
It's okay. Oh yeah, the poll is open now. So, and we have people who started voting, so excellent, we got back.
Thank you
and
so
now
much.
We have got several words, and I can, from the comments, so it's actually feminism, so adversarial, dicta, adversarial, dicta, obiter dicta, case, stare decisis, star decisis, barrister, And we have got several questions on what is your favorite legal movie while we're waiting for the answers from the poll. If you can recommend maybe, or like...
None.
None?
That's terrible. Okay, I would say 12, there's a movie made in the 1950s called 12 Angry Men, and it is about the deliberations in a jury room. Now, it is from a different time. It's all men. It's all white men, but it is a very realistic account of what could go on in a jury room. And I did that play with my students when I was teaching in the legal English program in Germany. So we had German law students come and be the jurors, and we had a great play, and many people came, and there were a lot of discussions. So I would say I have a soft spot for the film 12 Angry Men. It's also a famous American film. Henry Fonda, famous American actor, was the lead in that.
Yes,
okay.
And actually in Russia we also had this movie remade into Russian reality, and we have a Russian version of this movie. Actually, very interesting.
Mm-hmm. Oh, yes, I've heard about that. I would love to see that.
Yeah, and actually a lot of people don't realize that actually there is an original. So, and that's very nice of you to recommend it, because it's very interesting.
In one case, Russians borrowing from, we've borrowed so many wonderful film ideas from you, and I could talk about that for a long time. So I'm glad that you borrowed a wonderful film idea from us.
Yeah.
Okay, so let's see these words. Let's see these words. Oh, they're just not, it's not going to happen for me today.
It's okay. It's okay, absolutely.
Oh,
so,
let me try again.
Yeah, let's just try. Yes,
No.
we might see it. It happens. So, and
No.
showing
But
results.
Yes, give me some.
I can give you some more from the
Okay,
comments.
thank you.
So it's dicta, case, barrister, dicta, again adversarial, holis, some would like the word holis, inquisitorial, and dicta. So I think the tops are dicta, adversarial, and are some barristers and case. Yes.
Excellent. Those are fantastic words. So thank you so much. I am. We would say in British English, we would say I am dead impressed. I'm very impressed by the level of knowledge and the sophistication of the questions. I look forward to working with you on the 5 upcoming seminars. And the next one is a great seminar for common law, because it is a very case law heavy area of law, and that will be torts.
Okay, excellent. Thank you very much, Danielle, because it was an amazing webinar. We learned a lot. We learned so much. And thank you very much for your wonderful explanations. So, because they were fantastic. And everyone, yes, we are welcoming you to our next webinar on the 15th of March, the same time. And we are very grateful for your attention and for your participation. So a new journey begins. We have 5 webinars with Danielle, and we are happy to have her. See you in 2 weeks. Thank you and bye-bye.